Good evening, and welcome to Lawyers on the Line. I'm Sean Quinn, a partner with the Falsani Balmer, Peterson, Quinn, and Beyer law firm, and this evening's moderator. Tonight's topic is premises liability. People can suffer severe injury when on the property of others, whether in a hotel, restaurant, store, or apartment building. So what are the rights and obligations of those involved? That's what our panelists are here to discuss tonight. We have Jim Balmer of the Falsani Balmer law firm, Paula Polasky of the Falsani Balmer law firm, and J.D. Feriancek of Thibodeau, Johnson, and Feriancek trial lawyers. Jim, Paula, and J.D. are here to respond to your questions about premises liability. So give us a call right now at 218-788-2844. Or if that's long distance for you, call our toll-free line at 1-877-307-8762. Good evening, everyone.
Good evening.
Jim, I'm going to jump right in. Someone gets hurt on someone else's property. Everyone assumes the landowner is responsible for that person's injuries. True? Not true?
Not true. I think for a long time people just assumed that if you get hurt on somebody else's land, they owe you. But that's not the law. The law imposes on the landowner a duty of reasonable care. That is, he must act reasonably as a landowner. So he needs to make sure that any traps or potential pitfalls for injury to others are marked. If he feels he can't adequately protect people from these pitfalls, then he should close off the land and prevent people from entering onto it.
But reasonable care goes both ways. I mean, when the plaintiff or the individual comes on a person's property, they have an obligation to act reasonably too. They can't get drunk, they can't act in or enter into hazards that they know to be dangerous. So it goes both ways. It's not just the plaintiff.
True?
Sure.
Okay. Yeah. Okay. All right, Paula, someone does get hurt on somebody's property. They slip, they fall, they're hurt. What do they have to do now?
I think the best thing to do in that situation is if you're at a place of business or something like that, go to somebody that you think might be in charge and say, I got hurt, this is what happened. Typically there'll be an injury report or something that you can fill out. If you need medical attention, obviously make sure to get that. But really, if you do get hurt, it's focusing on your surroundings, seeing what the hazard was, what you slipped in, for example, what you fell on. If you have your phone handy and you're not seriously injured, if there's a big puddle on the ground, take a picture of the puddle. It's always helpful to have that later. If it's a big wavy wall of ice on the sidewalk, that's fine. But if you need medical treatment, get that. But if it's something that you can report, I would do that right away.
Okay. And then JD, what about the landowner? Let's say it's a business. What does a business owner do when somebody does get hurt on their property? What should they do?
I think the business owner's got a different perspective. I think first, if somebody is hurt or claims to be hurt, the business owner has an obligation to protect that individual, whether it be calling 911 or making certain that they're safe. The second thing that they should do is then preserve the scene. Make certain no other person can get into the scene so they're not interacting with it in a second, so someone else could get hurt. Then from a standpoint of protecting the property owner, take a picture. Find the witnesses, take the statements, and then at that point in time you clean the scene. But the first thing that any property owner should do after all of those things is done is call your insurance company. They're the ones that are going to be able to take care of you.
Okay. And that's after you take care of the injured person and
Absolutely.
all the other things.
Absolutely.
Okay. Now, Paul, I'll go to you. What if it's not a business, or even if it is a business, but the person isn't supposed to be there? They're trespassing. Can a trespasser bring a claim if they get hurt while trespassing?
Well, under certain circumstances, Minnesota law has two categories of people. There's trespassers, and then there's what you call an entrant, somebody who comes into your property with some sort of permission, directly or implied. If you're a trespasser, then there's a couple things that you look at. You look at if there was an open and obvious hazard. So say, for example, an individual constructed a, what we would call maybe a hidden trap. So they dug a big trench, they covered it with some leaves in the meantime or something while they were doing some construction on their land. And if they knew that trespassers would occasionally come onto their land in that area, then a duty may arise to either warn those people or at least put up some markers to note where that is, because you really want to avoid hidden traps even for people who might be on your property without your permission. If you had no idea that anybody might even come onto your land or something like that, there should be some sort of constructive or direct knowledge that the person is there or might be there.
Way back when I got out of law school, there was a very celebrated case.
That's a long time ago.
It's a very long time ago, but guns had been invented, and somebody down in Iowa had an empty building in which he had placed a spring gun.
Right.
And somebody walked into the building, obviously had no business being there, a trespasser, spring gun goes off, shoots him, and he got a recovery from the property owner. And all these people in Iowa and Minnesota were enraged, but that's the law.
You can't set somebody up,
Yeah.
build
Right.
a Burmese tiger
Yeah.
trap like Paula described
Yeah,
or something
you
like
can't
that.
set up a trap for
Yeah,
people.
right.
But the flip side of that is, though, is that the property owner doesn't know about the condition and has no knowledge of
Right.
the situation,
Right.
and an accident happens, and they're trespassing, not likely to be found liable.
Right. Now, Jim, Paula used a term when she was answering the question where she said, well, if it's an open and obvious danger.
Yes.
What does that mean from a legal perspective, open and obvious?
These days, it means to a judge a hazard that was discernible or noticeable to the victim of injury on casual inspection. If the person could have or should have seen the hazard but nevertheless encountered it, then it's considered to be an open and obvious hazard. And many judges in Minnesota these days are holding that people who are hurt by what the judge concludes is an open and obvious hazard cannot make a recovery regardless of whether they're trespassers or entrants. I believe that to be a change from prior Minnesota law, but that is the way many judges are viewing that these days.
But don't you
JD,
think that's the reasonable approach? I mean, the one trouble that I have in my practice is I see many plaintiffs who want to blame somebody for some activity, whereas in my mind, when somebody encounters an open and obvious condition, you should accept personal responsibility for doing something that I would consider to be silly or negligent on your own. So I don't think it's moving the law very far.
All right, well then let me ask you this, JD. Somebody is, let's say, going across a snow-covered sidewalk. They know it's snow, they know there's maybe ice there, but they have to. They're the mailman. Then how does that play?
I think that's a different exception. I think when you create a condition in which someone has to walk across it, whether it's open and obvious and they have to do something to do their job to get to their car, then I think the property owner's got a different responsibility. It's more along the lines of, did you have an alternative route? Did you have a safer alternative route to avoid that particular condition? And if you didn't and you had to go, it might be a little more difficult for a property owner to avoid responsibility.
One other thing I might add is, an owner can really pay attention to something that's been done on their property. Say a lot of people take an alternative route and there's a worn path cutting diagonally across their property or something like that. If something like that is happening, then there might be some knowledge that you can impute on the owner or possessor of the property that says, all right, even though this might not be the safest route, everybody who comes here takes the shortest route. It's right diagonally across. It's not maybe the safest way, but there's something to look at there too.
Okay.
What JD said, I think this needs to be added. What JD said sets up what I think the debate is in these kinds of cases and in many others that all of us handle. And that is personal responsibility versus the responsibility of the landowner or business owner for the safety of his customers. And a lot of people say, well, I think it's a matter of the person having to take care of himself. And others say, well, if the landowner or business owner is making a living off of the people he invites onto his property, perhaps he has a duty to take care of them. Obviously, it's an ongoing debate, and it's something that changes from situation to situation. But I've had voir dire or jury examination of people, and we've discussed exactly that, which is more important to each individual juror, and it's an ongoing dispute.
Okay. Doesn't the law basically put that obligation on both sides, that the landowner does have a responsibility to make things safe, especially if they're inviting people, but the individual who's on the property also has an obligation to look out for their own due care too.
I think the balancing factor, though, depends on the facts themselves. If there are some facts that are just so overwhelmingly, like somebody walked into a fire pit that's burning versus maybe an unleveled step, you see personal responsibility for the individual who walked in the fire pit greater versus an unbalanced step, and it just depends on the facts of the case.
And a lot of these are, I mean, this is really a jury question. You know, a lot of these assigning responsibility, things like that, those are things for a jury to decide.
Right.
Well, and along those lines, Paula, I'll follow up with you. Oftentimes juries are asked to decide what we lawyers call comparative negligence. Why don't you describe what that is?
Right, so comparative negligence in Minnesota means that a jury can assign fault or blame, responsibility at a trial. So they compare the plaintiff or the injured person's fault, especially if there's open and obvious issues in the case. You know, they might be 40% at fault, and they might assign the landowner 60%, or the opposite way around. And that will really affect if the person's able to recover. If the injured person is assigned a greater percentage of fault, then there won't be a recovery.
How does that work, Jim? This, you know, Paula described a 60-40 situation. How does that work as far as recovery for the injured person, and then how much the property owner might have to pay the injured person?
The injured person cannot recover from anyone unless their percentage of fault is greater than the injured person's. If the injured person is found, say, 40% at fault, the property owner is found 60% at fault, then the injured person gets to recover 60% of the harm he sustained, as set by the jury.
So if the jury says, well, your claim is worth $20,000, you get 60% of that $12,000.
Well,
Right.
do the math is a little easier. If it's 100,000, they'd get 60,000.
Okay.
I don't want to make it tough on you.
Well, I'd like to see those $100,000 verdicts more often, but yeah.
But interestingly, the juries don't know that. And in Minnesota state court, they're informed of the effect of their answers to the comparative fault question. But in the federal courts, they are not told of the effect of their answers.
Are they allowed to be told by the lawyers in
No.
federal court?
No.
Okay.
And in Wisconsin state court, they're not told of the effect of their answers. So some people think the jury should not know. Some people think, well, of course the jury ought to be told what they're doing. So, you know, but that's another one of those little twists of comparative fault.
Okay. All right, we have some questions from callers now. Questioner from Cromwell. Go to you, JD. What if someone breaks into your house and they get hurt while breaking into your house? I won't ask, can they bring a claim? Because of course they can bring a claim. Right. Are they likely to be successful?
Not likely to be successful, absent what we talked about, these hidden dangers. If you've got the spring-loaded gun or some condition where you have a situation where you're purposely trying to hurt somebody. In this situation, broken into a house, hurt themselves maybe through the window or tripping over something, we're in an entirely different situation of intentional conduct that would, in my assessment, take this really out of a case that even no plaintiff's firm would even want to touch anyway, no matter what.
Agreed, Jim?
Depends.
No.
Maybe if the injuries are severe enough, they might go for it that way, but yes.
Yeah. Did you have the thought, Paula? You look like you were thinking that.
The only twist I can see on that, and this was a bar exam scenario a while back,
not as far as Jim.
Was if somebody, you know, if it was a freezing blizzard outside and the person, you know, had a risk of dying of hypothermia or something.
So they
and somebody
had to break
wasn't,
in.
So they had to break in. I'm not sure exactly how that might change things, but yeah, if it's just a person wanting to come in and rob you, that's probably.
But there was a case in Duluth where a guy sat in a bar drinking all night, and the bartender kept serving him. He wandered outdoors into the storm, and he froze to death. And the family of the dead person sued the bar. That was a dram shop case, which we all know is slightly different, for the illegal sale of beverages to an intoxicated person. and the jury denied a recovery. So, but your comment triggered that.
All right, so let's go to another question from a viewer. What is a homeowner's liability for a swimming pool in their yard, Jim?
Oh. Well, the thing that we all focus on, I think, is kids. Kids love to go, hang around swimming pools, especially in hot weather. And if you know that you have a swimming pool there, we used to have a rule in Minnesota called attractive nuisance. Now that rule technically has been abrogated by the courts, but as a practical matter, it remains the case that if you know you have a feature of your property that attracts young people, you have to take reasonable steps to protect them from being injured by it.
Okay.
That's my view. I'm not sure what JD's is. Or
well, I have personal experience with it. I have a swimming pool in my backyard, and we make certain that the cover is in place so that nobody can access it when we're away. And then when individuals happen to be at the place, we have adult supervision to the extent that it's necessary. If kids are older, obviously not. So we're always monitoring the situation, and we hope people don't maybe drink too much if there's a particular party or something like that. But it's always on the responsibility of the property owner with a condition like that.
Okay. You choose to have a swimming pool, you got to take extra responsibility.
Absolutely.
Now, there's a follow-up from the same questioner. Does that person, or should that person, buy special insurance or a rider on their homeowner's insurance policy for a swimming pool?
Again, I can only just speak from personal experience. There are certain carriers that will take a pool. There are certain carriers that won't. Some of them require fences. Some of them require additional covers and things of that nature. It's all going to depend on the respective insurance carrier.
I think you should take special precautions if you live in an area where you know that children are bound to be wandering by, spotting the pool, and be attracted to that. So even if the rule, the attractive nuisance rule, technically went away, just take extra precautions if you know or do know already if you've seen kids wander onto your property for that.
All right.
When
I
I used to have a Doberman dog, and my insurance guy, when he was first insuring us, he looked at me and smiled engagingly and said, "Do you have a dog?" "Yes," I said, "a Doberman." I thought he was talking about burglary. But, you know, and he wasn't. He was worried about the dog attacking somebody. And he explained to me later that there was a possibility his company would not insure us if we had a dangerous dog. It turned out the dog was not dangerous. But he didn't know that when I first told him.
Okay. Well, let's have a follow-up on that. What is the responsibility of a homeowner who owns a dog?
Who do you want to?
I'll go to you. You're the Doberman owner.
Well, before we got the statute in Minnesota, there was a phrase, and we've all heard it, every dog deserves one bite. And what that means is that a homeowner is not legally responsible for something his dog does unless he knows or has reason to know the dog has a dangerous propensity. Typically, you learn that if you find out the dog bit somebody, and now you know the dog will bite people. You have a responsibility to protect others, including strangers, from the dog. Now, we have a statute in Minnesota.
So there used to be one free bite.
Yes.
In Minnesota.
But now, under Minnesota and Wisconsin law as well, it's called a first bite statute, which holds the homeowner legally responsible for the first bite the dog inflicts on somebody. So you have a responsibility to protect people from your dog, even if you have no reason to believe the dog will be dangerous. And if the dog does attack somebody, then you have what we lawyers call strict liability. It's not absolute liability, but it's strict liability, which means you're responsible, even if you had no reason to know the dog was dangerous.
Absent one exception, provocation.
Yes.
So if you were to antagonize the dog in such a way that it would bite, typically we don't see these cases as a defense firm, insurance defense firm, which I mostly do in our law firm anymore, because it is strict liability. There's typically no provocation, so it's just more of a valuation of the scar or the injury that follows. So you just don't see those very often, as much as you guys probably do on your end of the scale.
But if you go up to a dog and you just taunt it, then the dog gets a free bite.
Yeah. And yet, go ahead, Paula.
And I just had one of these cases. You know, even if you get injured while the dog is you know, going after something else like in your arms. So my client was holding her cat, and the dog went after the cat. They argued, so that shouldn't matter. But under the law, that doesn't matter. If you get hurt while the dog is attacking something in your arms, it's still you're still liable for that.
But the first bite statute also does not protect the trespasser.
Okay.
Go ahead, sorry.
No, that's excellent. All right, another caller, Cloquet. A man has a tree on his property. The branches lean over the neighbor's yard. The neighbor parks under the tree. What if the branch falls and hits the car?
Isn't that a commercial?
Yeah, it's also a case I studied in law school.
Yes, that's not the case of the
Case
thorns.
of the thorns.
It's a case of the thorns.
Yeah.
Oh, so Jim?
Well, I didn't do very well on that. It was, I believe that that amounts to a tort that is actionable. I'm certainly willing to stand corrected by my colleagues, but I think it is
that's right.
actionable.
I think the only situation where a property owner wouldn't be responsible is if a large gust of wind caused it in an unexpected fashion and the tree was properly maintained and it was just, you know, it was a healthy tree and it just broke. I think you might have an act of God defense for a situation like that, but if you know it's tipping over and you know it's a problem,
it's leaning,
Right.
then all of a sudden I think you're again, report it to your insurance carrier.
Okay. JD, caller from Carlton. Man owns a cabin. He has his friends over. Somebody gets hurt. Now, the question is the owner liable? I think we've kind of answered that question already regarding, you know, just because someone gets hurt on your property.
Right. I think it would all depend on what was the individual doing. Had he been drinking? Had he been doing something a bit unusual or inappropriate? But typically speaking, yes, liability would fall.
So then he has a follow-up. What if the cabin is owned under an LLC? Does that protect the owner?
Well, it protects the owner in an individual context, but the LLC is still an entity that's capable of being sued.
Sure.
Presumably the LLC has insurance, and you'd be going after the LLC. Now, is the corporation correct? Is it been established in a proper fashion? Boy, I don't know. But the individual arguably has immunity through the corporation.
Okay, I got two really good questions here, so I'm going to ask Paula. You'll get the first one.
Great.
Someone is flying a drone over another person's property
Okay.
just to be snoopy. Can the property owner shoot down the drone? And actually, obviously, the property owner can. Would they be responsible to pay for the drone that they just shot down?
That's a fascinating hypothetical. You know, there are so many layers to that. There's privacy layers. There's, you know, fear, or if you're afraid of if it's flying very, very close to your house. You know, I wouldn't suggest shooting it down. I would call the police first and see what happens there. But I think.
See, I disagree.
You know,
if that's over my yard and I'm in a safe environment where I can't hurt anybody with my shotgun blast.
Okay. All right. So
in your home
you
is
live
your castle,
you live out in the country where you got 20 acres. That's one thing. You live right in a real tiny neighborhood right here in town. That might be a different thing.
Well, there's a whole different criminal I would
Right.
for discharging in city limits.
Right. Yeah. So, all right, Jim, caller from Cloquet. A woman owns 40 acres of land. No trespassing signs up all over. Someone goes on the land anyway and gets shot. I'm not sure about you. Is the owner liable? Let's assume the owner didn't actually pull the trigger.
If the owner didn't shoot him, I don't see, and the owner presumably had no reason to know somebody was wandering around on the owner's property with a firearm, I don't see how the owner is legally responsible for that. But to the extent that the shooting victim can show that the owner knew or perhaps even participated in the shooting, I'd say the owner has a problem.
And if you know, the person wandered onto the land, even if it was accidental, unknowing, didn't see a sign, you still can be considered a trespasser. So the duty is different, and the standard of care is different in that situation.
I don't think the individual, if they're on the land, walking in a trespassing fashion, and somebody is deer hunting. I'm presuming that's what the question is envisioning. And if somebody is shooting at a deer in an appropriate fashion and doesn't know anyone's behind him and has no reasonable expectation to think that somebody's going to be behind him, I can't imagine a court holding somebody in an irresponsible fashion for just firing a gun. Otherwise, every deer hunter who fires a gun would be held responsible for what's behind him in an unknowing fashion. I agree. If you know somebody's there, you got a problem.
Right.
But I think it'd be difficult.
And we only have about 30 seconds left, but some states have, and this is sort of related, stand your ground and king of the castle laws. What do we have in Minnesota, Jim?
We don't, so far as I'm aware, the legislature's in session, and as Mark Twain said, no one's property is safe when that's going on. But at last I checked, we don't have a stand your ground or a castle, man's home is his castle law. That means that you do not have a right to shoot somebody in your house unless they menace you physically, then you can shoot them. If you have a man's home is his castle statute, then you can shoot them if they're in your house. If you have a stand your ground, you don't even have to be in your house and you can shoot them.
Okay, because there's a lot of talk about that in the media over the past couple of years. So, all right, very good. Well, thank you all for excellent answers. That's all the time we have tonight. Remember, you can watch our show again online at www.wdse.org or at www.duluthtriallawyers.com. Please join us next week when we'll talk about automobile collisions. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Sean Quinn. Good night.